A few provisions of the Patriot Act dealing with wiretapping and surveillance expire tonight at midnight. The House is coming back in to work on an extension of the bill. Live on C-SPAN.
Received the following message from the Secretary of the Senate on May 26, 2011 at 2:50 p.m. that the Senate passed Senate 1082, that the Senate agreed to Senate Concurrent Resolution 13, Appointments Advisory Committee on the Records of Congress. With best wishes, I am, signed sincerely, Karen L. Haas.
Chair lays before the House a communication.
The Honorable the Speaker, House of Representatives. Sir, pursuant to the permission granted in Clause 2H of Rule 2 of the Rules of the U.S. House of Representatives, the Clerk received the following message from the Secretary of the Senate on May 26, 2011 at 6:25 p.m. that the Senate concur in House amendment with an amendment, Senate 990. With best wishes, I am, signed sincerely, Karen L. Haas.
For what purpose does the gentleman from Alabama seek recognition?
Mr. Speaker, I present a privilege report for printing under the rule.
The clerk will report the title.
Report to accompany H.R. 2017, a bill making appropriations for the Department of Homeland Security for the fiscal year ending September 30th, 2012, and for other purposes.
Referred to the Union calendar and ordered printed. Pursuant to Clause 1 of Rule 21, all points of order are reserved. For what purpose does the gentleman from California rise?
Mr. Speaker, I send to the desk a privilege report from the Committee on Rules for filing under the rule.
Clerk will report the title.
Report to accompany House Resolution 281, resolution providing for consideration of the Senate amendment to the House amendment to the bill, Senate 990, to provide for an additional temporary extension of programs under the Small Business Act and the Small Business Investment Act of 1958 and for other purposes.
Referred to the House calendar and ordered printed.
Speaker.
For what purpose does the gentleman from California...
Speaker, I ask unanimous consent that when the House adjourns today, to adjourn to meet at 10 a.m. tomorrow, and further when the House adjourns on that day, to adjourn to meet at noon on Tuesday, May 31st, 2011, for morning hour debate and 2 p.m. for legislative business.
Without objection, so ordered.
Speaker.
Gentleman from California.
Mr. Speaker, I ask unanimous consent that when the House adjourns today, to adjourn to meet at 10 a.m. tomorrow, and further when the House adjourns... okay, I didn't need to do that again.
What purpose does the gentleman seek?
Mr. Speaker, by direction of the Committee on Rules, I call up House Resolution 281 and ask for its immediate consideration.
Clerk will report the resolution.
House Calendar Number 41, House Resolution 281. Resolved that upon adoption of this resolution, it shall be in order to take from the Speaker's table the bill, Senate 990, to provide for an additional temporary extension of programs under the Small Business Act and the Small Business Investment Act of 1958 and for other purposes, with the Senate amendment to the House amendment thereto, and to consider in the House, without intervention of any point of order, a motion offered by the Chair of the Committee on the Judiciary or his designee, that the House concur in the Senate amendment to the House amendment. The Senate amendment shall be considered as read. The motion shall be debatable for 1 hour, with 40 minutes equally divided and controlled by the Chair and Ranking Minority Member of the Committee on the Judiciary, and 20 minutes equally divided and controlled by the Chair and Ranking Minority Member of the Permanent Select Committee on Intelligence. The previous question shall be considered as ordered on the motion to final adoption without intervening motion.
The gentleman from California is recognized for 1 hour.
Speaker, for the purpose of debate only, I yield the customary 30 minutes to my good friend from Boulder, Mr. Polis, pending which I yield myself such time as I may consume, and all time yielded be for debate purposes only. Mr. Speaker, we have before us a hard-fought compromise for a 4-year extension of the Patriot Act. We know that there are 2 priority items that need to be addressed here. Number 1, ensuring that we do not face another terrorist attack against the United States or our interests, and number 2, equally important, to preserve the civil liberties and the constitutional protections that the American people have. This compromise does just that. We had a 3-month extension. The House Judiciary Committee, and specifically Mr. Sensenbrenner's subcommittee, had 3 hearings. we see a bipartisan and bicameral compromise before us, and I urge my colleagues to support the rule and the underlying legislation. With that, reserve the balance of my time.
Gentleman reserves his time. The gentleman from Colorado.
Thank you, Mr. Speaker. There has been a major development in the war on terror in the last few weeks with the successful defeat of Osama bin Laden, striking a major blow to al-Qaeda. At a time like this, we should re-examine the restoration of our constitutional protections. There's no reason to continually extend these Patriot Act provisions without taking a close look at them. Mr. Conyers, my colleague from Michigan, put forward an excellent proposal that's an example of the many thoughtful bipartisan proposals that would improve the Patriot Act, keep the American people safe, and protect our constitutional rights. Unfortunately, discussion of that proposal and debate and a vote on that proposal is not allowed under this rule, and therefore I'm opposed to the rule and the underlying bill, and I reserve the balance of my time.
Gentleman reserves his
Mr. Speaker,
time.
I'm prepared to close.
Gentleman from Colorado.
I yield myself such time as I may commit.
Gentleman's recognized.
Mr. Speaker, this bill would specifically reauthorize three provisions, Section 215, 206, and 6001 of the Intelligence Reform and Terrorism Prevention Act. Section 215 allows the government to capture any tangible thing that might be relevant to a terrorist investigation. That could include medical records, your diary, even what books you've checked out at the library. Now, in the past, these orders were limited to narrow classes of businesses and records, but the Patriot Act has stripped away these basic requirements and continues to violate a basic American principle of privacy. Section 206, the second provision of the bill, allows the government to conduct roving wiretaps. This allows the government to obtain surveillance warrants that don't specify the person or the object to be tapped. Could be an entire neighborhood. So much for the Fourth Amendment of the Constitution, which states that warrants must specify the person and place to be seized and searched with, quote, particularity. This is to make sure the executive branch doesn't have the unfettered powers that this version of the Patriot Act would continue to give them for 4 years. The final section that would be reauthorized under this bill, Section 6001, deals with the lone wolf provision. This allows secret surveillance of non-citizens in the U.S., even if they're not connected to any terrorist group or foreign power. This authority is only granted in secret courts and threatens our understanding of the limits of our own government's investigatory powers within our own country's borders. Now, we're told that government has never used this power, so I ask my colleagues, why should we reauthorize it? If it hasn't even been used, shouldn't it be allowed to expire, particularly in light of our recent successes in the war on terror and the defeat of Osama bin Laden? My friends on the other side of the aisle say they're worried about the growth of government, yet in spite of the rhetoric, this bill grows government and takes away privacy and respect for our private lives. This is a type of government intrusion which the Bill of Rights was designed to prevent. The provisions in the Patriot Act continue to be an affront to our most basic liberties as American citizens. I urge anyone who's worried about the unchecked growth of the state to think twice about this bill, perhaps look at a short-term extension, and have a real discussion of restoring the balance between individual rights and security. I urge a no vote on the rule and the underlying bill, and I yield back the balance of my time.
Gentleman yields back his time. The gentleman from California.
Speaker, I yield myself such time as I might consume to simply say that this is a hard-fought compromise. It's a 4-year extension. We've had exhaustive hearings on this issue. We need to ensure our security, number one, and we also need to ensure our civil liberties, and I believe that this measure does just that. It's passed the Senate by a vote of 72 to 23. I urge my colleagues to support the rule and the underlying legislation. I ask unanimous consent that all members may have 5 legislative days in which to revise and extend their remarks. And with that, I yield back the balance of my time and move the previous question.
Without objection, the previous question is ordered. The question is on adoption of the resolution. All those in favor signify so by saying aye. Those opposed, no. The ayes have it. The resolution is adopted, and without objection, a motion to reconsider is laid upon the table.
Oh, I'm not ready yet.
House will be in order.
Give me
For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, pursuant to House Resolution 281, I call up S990 with the Senate amendment to the House amendment thereto, and I have a motion at the desk.
The clerk will report the title of the bill, designate the Senate amendment, the House amendment to the Senate amendment, and report the motion.
Senate 990, an act to provide for an additional temporary extension of programs under the Small Business Act and the Small Business Investment Act of 1958 and for other purposes. Senate amendment to House amendment. Mr. Smith of Texas moves that the House concur in the Senate amendment to the House amendment to Senate 990.
Pursuant to House Resolution 281, the motion shall be debatable for 1 hour with 40 minutes equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary, and 20 minutes equally divided and controlled by the chair and ranking minority member of the Permanent Select Committee on Intelligence. The gentleman from Texas, Mr. Smith, and the gentleman from New York, Mr. Nadler, will each control 20 minutes. The gentleman from Michigan, Mr. Rogers, and the gentleman from Maryland, Mr. Ruppersberger, each will control 10 minutes. The chair recognizes the gentleman from Texas, Mr. Smith.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous materials on S990.
Without objection, so ordered.
Mr. Speaker, I yield myself such time as I may
Gentleman is
consume.
recognized.
Mr. Speaker, 4 months from now, America will mark the 10-year anniversary of the worst terrorist attack in U.S. history. Tonight at midnight, 3 national security provisions that have helped prevent another 9/11 attack will expire. Congress must do its job and approve this legislation to reauthorize them before time runs out. Some argue that since we haven't had a major terrorist attack since September 11th, we no longer need these laws. Others argue that the death of Osama bin Laden brought an end to al-Qaeda and the war on terror. But both of these claims lack merit. The Patriot Act provisions continue.
From Georgia is correct. The House is not in order. The gentleman from Texas may proceed.
Mr. Speaker, the Patriot Act provisions continue to play a vital role in America's counterterrorism efforts, not only to prevent another large-scale attack, but also to combat an increasing number of smaller terrorist plots. Earlier this year, a 20-year-old student from Saudi Arabia was arrested in my home state of Texas for attempting to use weapons of mass destruction. Khalid al-Dosari attempted to purchase chemicals to construct a bomb against targets, including the Dallas residence of former President George W. Bush, several dams in Colorado and California, and the homes of 3 former military guards who served in Iraq. Information obtained through a Section 215 business records order was essential in thwarting this plot. Make no mistake, the threat from terrorists and spies is real. These provisions are vital to our intelligence investigations, and they are effective. We also have heard repeatedly from the Obama administration about the critical importance of extending these laws. S990, the Patriot Sunsets Extension Act of 2011, is a bipartisan, bicameral compromise to reauthorize the existing Patriot Act provisions for another 4 years. By doing so, Congress is ensuring that critical intelligence will be collected and terrorist plots will be disrupted. In February, Congress approved a 90-day extension of these provisions. During the last 3 months, the House Judiciary Committee has thoroughly reviewed the Patriot Act and how its provisions are used in national security investigations. The Crime Subcommittee has held 3 hearings specifically on the Patriot Act. The full committee held oversight hearings at the FBI and the Department of Justice, and all committee members were provided a classified briefing by the administration. Attorney General Eric Holder told the committee that he supports these provisions and encouraged Congress to reauthorize them for as long of a period of time as possible. The roving wiretap provision allows intelligence officials, after receiving approval from a federal court, to conduct surveillance on terrorist suspects regardless of how many communication devices they may use. We know terrorists use many forms of communication to conceal their plots, including disposable cell phones and free email accounts. Roving wiretaps are nothing new. Domestic law enforcement agencies have had roving wiretaps for criminal investigations since 1986. If we can use roving wiretaps to track down a drug trafficker, why shouldn't we also use it to prevent a terrorist attack? The business records provision allows the FBI to access third-party business records in foreign intelligence, international terrorism, and espionage cases. Again, this provision requires the approval of a federal judge. That means the FBI must prove to a federal judge that the documents are needed as part of a legitimate national security investigation. These two provisions have been effectively used for the last 10 years without any evidence of misuse or abuse. Our national security laws allow intelligence gathering on foreign governments, terrorist groups, and their agents. But what about a foreign terrorist who either acts alone or cannot be immediately tied to a terrorist organization? The lone wolf definition simply brings our national security laws into the 21st century to allow our intelligence officials to answer the modern-day terrorist threat. Since 9/11, we have seen terrorist tactics change. In addition to coordinated attacks by al-Qaeda and other groups, we face the threat of self-radicalized terrorists who are motivated by al-Qaeda but may not be directly affiliated with such groups. The lone wolf definition ensures that our laws cover rogue terrorists even if they aren't a card-carrying member of al-Qaeda or another terrorist organization. The terrorist threat will not sunset at midnight, and neither should our national security laws. The Patriot Act is an integral part of our offensive against terrorists and has proved effective at keeping America safe from terrorist attacks. Mr. Speaker, I urge my colleagues to support this reauthorization, and I'll reserve the balance of my time.
I'm the gentleman from New York.
Thank you, Mr. Speaker. Mr. Speaker, I yield myself such time as I may consume.
Recognized.
Mr. Speaker, I rise today in opposition to this extension of the 3 expiring provisions of the USA Patriot Act and the Intelligence Reform of Terrorism Prevention Act. When we last considered these expiring provisions, it was to extend them temporarily so that the House could review them and consider whether to improve them or allow them to expire. Many members on both sides of the aisle objected to extending these provisions without so much as a hearing or an opportunity to debate changes to the law. In fact, the extension was rejected the first time with the votes of both Democrats and Republicans. Since that debate, Chairman Sensenbrenner did in fact hold a series of hearings in which members of the Judiciary Committee were able to consider the issues and hear from many thoughtful experts who were able to make helpful suggestions. These 3 provisions dealing with roving wiretap authority, expansion of the definition of an agent of a foreign power to include so-called lone wolves, and Section 215, which allows the government to obtain business and library records using an order from the Foreign Intelligence Surveillance Court instead of the normal methods, have aroused a great deal of controversy and concern, and rightly so. Section 215 authorizes the government to obtain, quote, any tangible thing, unquote, relevant to a terrorism investigation, even if there is no showing that the thing pertains to suspected terrorists or terrorist activities. Section 215 is sweeping in its scope, and the government is not required to show reasonable suspicion or probable cause before undertaking an investigation that infringes upon a person's privacy. Congress should either ensure that things collected with this power have a meaningful nexus to suspected terrorist activity or should allow this provision to expire. Section 206 provides for roving wiretaps, which permit the government to obtain intelligence surveillance orders that identify neither the person to be tapped nor the facility to be tapped. There is virtually no particularity required. This seems a clear violation of the Fourth Amendment. There are almost no limits on this authority and no requirement that the government name a specific target, either a person or a location. Section 6001 of the Intelligence Reform and Terrorism Prevention Act of 2004, the so-called lone wolf provision, permits secret intelligence surveillance of non-U.S. persons who are not affiliated with a foreign government or organization. According to government testimony, this provision has never been used, yet we are told it is vital that it remain on the books. Surveillance of an individual who concededly is not working with a foreign government or with a terrorist organization is not normally what we understand as foreign intelligence. There may be many good reasons for government to keep tabs on such an individual, but there is no reason to suspend all our normal laws under the pretext that this is a foreign intelligence operation. We are now told we must simply punt for a few years. No need, we have been told, to consider any of the many improvements that many members believe are important. No need, in fact, even to have a debate or a vote on those changes. It's another my way or the highway vote. That is no way to protect our nation from terrorism while protecting our fundamental liberties from government intrusion. I realize that the Republican majority has the votes to extend these expiring authorities, but I am proud to stand with my colleagues of both parties in opposition to the flippant and reckless way in which our liberties are being treated today. I urge my colleagues to reject this dangerous legislation and demand that the House have a serious debate on the important issues impacted by this legislation affecting our security and our liberty. I reserve the balance of my time.
The gentleman reserves his time. The gentleman from Texas.
Mr. Speaker, I'll continue to reserve my time as well.
Gentleman reserves his time. Gentleman from New York.
Then, Mr. Speaker, I now yield 2 minutes to the gentlelady from Texas.
Gentlelady from Texas is recognized for 2 minutes.
I thank the gentleman very much, and I rise today to support a 7-day extension, which means I believe that we can fix these problems. And I'm disappointed that we again, having been given the responsibility of oversight, now rush for a 2-page document, that is now the essence of the Patriot Act, which in fact will provide some challenge to the civil liberties of all Americans. I highlight just one or two. The business records applies to citizen and non-citizens alike, where law enforcement or government authorities can come and take items no matter what their relevance, if they think that they might have some relevance to terrorism, any tangible thing. Restaurants, where you've gone to a restaurant, they can ask for what you ate. A hotel, your records. Libraries, your records. Why couldn't we do this with a 7-day review time? Extend it for 7 days today and allow us from New Hampshire to Texas to California to be able to say that we stand with our soldiers in securing the nation, but we also believe in civil liberties. Let me remind my colleagues, 9/11 and the terrorists that we were shocked that could find their way to lift off and not take off, that was a question of not connecting the dots. Not that we didn't have the information. We didn't connect the dots of information that was sitting on the desk of an agent in the Midwest and information that was somewhere else. Intelligence, getting information, analyzing it, is part of securing the homeland, not violating the rights of Americans. So here we go again. Business records with no restraint. Not adding the civil liberties and oversight provisions that were found in John Conyers' legislation, the ranking member on judiciary, and as well the chairman of the Judiciary Committee in the Senate, Chairman Senator Leahy. What is the rush to protect those who are, in fact, citizens of the United States? What is the rush not to protect them? Support a 7-day extension. Don't vote for legislation that violates the civil liberties of Americans. With that, I yield back.
Gentlelady's time has expired. The gentleman from Texas.
Mr. Speaker, I yield 5 minutes to the gentleman from Wisconsin, the current chairman of the Crime Subcommittee of the Judiciary Committee and a former chairman of the Judiciary Committee.
Gentleman from Wisconsin is recognized for 5 minutes.
Mr. Chairman, I thank the gentleman for yielding. I rise in support of Senate 990 to reauthorize the 3 expiring provisions of the Patriot Act for 4 years. This legislation provides much-needed certainty to our intelligence officials who rely on these tools to prevent terrorist attacks, monitor foreign spies, and prevent espionage. Unfortunately, this bill does not go as far as legislation reported by the Judiciary Committee earlier this month. H.R. 1800, the bill I sponsored along with Judiciary Chairman Smith, Intelligence Chairman Rogers, and House Administration Chairman Lundgren, permanently reauthorized the lone wolf definition and extends Section 206 roving authority and Section 215 business records authority for 6 years. The Patriot Act has been plagued by myths and misinformation for 10 years. We've heard some of those tonight, and we'll probably hear more. In the last 3 months, myths have become even more outlandish. Claims of warrantless wiretapping, monitoring entire neighborhoods, and blatant constitutional violations. Make no mistake, each and every one of these claims are patently false, and if Congress fails to reauthorize these laws before they expire, America's national security and that of its citizens will be the most vulnerable in a decade. The lone wolf definition closes a gap in FISA by allowing the government to track a foreign national, not a U.S. person, who engages in acts to prepare for a terrorist act against the United States, but is not affiliated or cannot immediately be shown to be affiliated with a foreign terrorist organization. The lone wolf definition is in fact quite narrow. It cannot be used to investigate U.S. persons and only applies in cases of suspected international terrorism. The government cannot use this provision to investigate domestic terrorism. Although the lone wolf provision is yet to be used, it is an important provision that recognizes the growing threat of individuals who may subscribe to radical or violent beliefs but do not clearly belong to a specific terrorist group. The recent death of Osama bin Laden only strengthens its importance as the fear of individual retaliatory acts increases. Section 206 of the Patriot Act authorizes the use of roving or multi-point wiretaps for national security and intelligence investigation. This allows the government to use a single wiretap order to cover any communications device that the target is using or is about to use. Without roving wiretap authority, investigators must seek a new court order each time a terrorist or spy changes cell phones or computers. In today's world of disposable cell phones, free email accounts, and prominent social media, roving authority is a crucial tool. Section 215 allows the FISA court to issue orders granting the government access to business records in foreign intelligence, international terrorism, and clandestine intelligence cases. This authority is similar to the widely accepted grand jury subpoena in criminal investigations. There are numerous protections written into the law to ensure that the authority is not misused. Under Section 215, only an Article III FISA judge can issue an order for business records. An investigation of a U.S. person cannot be based solely on activities protected by the First Amendment, and the records must be for a foreign intelligence or international terrorism investigation, and minimization procedures must be utilized. In addition, requests for records of library circulation, book sales, firearm sales, and the like must first be approved by the FBI director, his deputy, or the head of the FBI's National Security Division. By contrast, a grand jury subpoena can obtain all of these records in a criminal investigation with simply the signature of a line prosecutor. Finally, business records, which by definition reside in the hands of a third party, do not, and I repeat, do not implicate the Fourth Amendment. Since this law was first enacted over 10 years ago, these provisions have been scrutinized to the fullest extent of the law and have either been unchallenged or found constitutional. The lone wolf definition has never been challenged. Section 206 roving wiretaps have never been challenged. But 4 appellate courts, including the Ninth Circuit, have upheld criminal roving wiretap authority under the Fourth Amendment. Section 215 business records were challenged, but after Congress made changes to that provision in the 2006 reauthorization, which many people who are complaining about this bill voted against. Have one more minute.
Mr. Speaker, I'll yield the gentleman an additional minute.
The lawsuit was withdrawn. These 3 provisions have stopped countless potential attacks and play a critical role in helping ensure law enforcement officials have the tools they need to keep our country safe. The death of Osama bin Laden proves that American intelligence gathering is vital to our national security. The fight against terrorism, however, did not die with bin Laden, and neither did the need for the Patriot Act. I urge my colleagues to support this legislation and yield back the balance of my time.
Gentleman yields back the gentleman from New York.
Mr. Speaker, I now yield 2 minutes to the gentleman from Ohio.
The gentleman from Ohio is recognized for 2 minutes.
Speaker, I rise in strong opposition to another abdication of our constitutional duty to conduct oversight and protect our most basic civil liberties. This bill extends through June 1, 2015, 3 provisions contained in the Intelligence Reform of Terrorism Prevention Act and the USA Patriot Act that at the time of their passage constituted an unprecedented expansion of government power and infringement on the American people's privacy. Earlier this month, the Department of Justice released its annual report on surveillance activities for 2010. The report reveals that the government quadrupled its use of Section 215 orders, named after one of the provisions were poised to extend until 2015 with no reform. Section 215, also known as the Business Records Provision, allows the FBI to order any person, any business, to turn over any tangible things as long as it specifies it's for an authorized investigation. Orders executed under Section 215 constitute a serious violation of the Fourth Amendment and the First Amendment rights by allowing the government to demand access to records often associated with the exercise of First Amendment rights, such as library records or medical records. The other amendments to be extended include Section 601, the Lone Wolf Surveillance Provision. It's contained in the Intelligence Reform and Terrorism Prevention Act of 2004, authorizes the government to conduct investigations of non-U.S. individuals not connected to any foreign power or terrorist group. It effectively allows the government to circumvent the standards that are required to obtain electronic surveillance orders from criminal courts. Lastly, Section 206, known as the John Doe wiretap, allows the FBI to obtain an order from the Foreign Intelligence Surveillance Court to wiretap a target without having to specify the target or the device. These provisions were given a sunset for a reason. There's an abundance of evidence over the last 10 years that these powers have given the government license to infringe on constitutionally protected privacy of the American people with no accountability. It's time we stop rubber stamping these provisions, reform the Patriot Act, stop big government from reaching into people's private lives. Yield back.
Gentleman's time has expired. The gentleman from Texas.
Mr. Speaker, may I ask how much time remains on each side?
The gentleman from Texas has 9 minutes remaining, and the gentleman from New York has 12.5 minutes remaining.
Okay. Mr. Speaker, we'll reserve the balance.
The gentleman reserves his time. The gentleman from New York.
Thank you, Mr. Speaker. I now yield 2 minutes to the gentleman from New Jersey, Mr. Holt.
The gentleman from New Jersey is recognized for 2 minutes.
Mr. Speaker, the House is once again in an unexamined rush to make semi-permanent the government's ability to seek all manner of records on citizens without having to demonstrate to a court that citizens under suspicion are actually engaged in terrorist activities. The power of government for surveillance and enforcement are among the most important, but also the most fearsome. We know these authorities and others have been abused because the Department of Justice Inspector General has told us so. I know it because for 8 years I served on the House Permanent Select Committee on Intelligence. Let me tell you, American freedom and security are not well served by the excessive secrecy imposed on our society and government or by this legislation. The Foreign Intelligence Surveillance Court, which is responsible for approving government surveillance requests under the Patriot Act, is the kind of court that should be used only rarely and in the most special circumstances. Instead, it has become a kind of routine clandestine government. Treating some Americans as above suspicion and others as suspect without cause has made us a less just and also a less secure society. The Patriot Act was originally passed at a time of high emotion in this country. Nearly a decade after the Patriot Act enactment, the death of Osama bin Laden has provided us with an opportunity to stop and reflect on all that has transpired over the last 10 years. It is past time for us to pause and re-examine the validity of the assumptions that led to the passage of the Patriot Act and the validity of its current application. But you say we cannot debate the validity of its current application because those applications are classified at a very high level. That is precisely one of the points we should be debating thoroughly before any reauthorization. Sitting on the House Permanent Select Committee on Intelligence for 8 years, let me tell you, that secrecy does not serve America well. I yield back my time.
The gentleman's time has expired. The gentleman from New York, from Texas.
Mr. Speaker, I'll yield 4 minutes to the gentleman from California, Mr. Lundgren, Chairman of the House Administration Committee and also a senior member of the Judiciary Committee.
The gentleman from California is recognized for 4 minutes.
I can't hear.
The gentleman. The House will be in order.
Thank you very much, Mr. Speaker. Mr. Speaker,
I know we want to get to a vote very, very soon, and normally I would refrain from speaking on this, except that because this is such an important issue and some of the things that have been stated on the floor are so patently untrue, there's an obligation for those of us who have been working on this issue for some period of time to make sure that the public is not misled by statements that have been made here on the floor. Number one, the Fourth Amendment is not implicated.
And suspend. Will the House be in order? Can the individuals having conversations to my right please take their conversations off the floor? Gentleman from California may continue.
Thank you very much, Mr. Speaker. We have heard statements on this floor that are absolutely not true. They're the same statements that were made the last time we had this on the floor, the same statements that were made when we reauthorized this a few years ago. And one of the most amazing things is there's a continuation of this argument that we haven't done proper oversight. I don't know where you have been, but many of us on this side of the aisle have been in briefings and on hearings on these very issues, seeking out the truth on these things. The canard that somehow we are tearing the Constitution up just does not stand any kind of inquiry whatsoever. The suggestion that somehow we are invading the civil liberties of citizens is negated by the language in the three sections of the bill that we have before us. And the argument that somehow, since we got rid of Osama bin Laden, we don't need this, is the most absurd of all. One of the lessons of our successful mission being executed against Osama bin Laden is that you need actionable intelligence over a long range of time that you can connect together with analysis to give you the information that you need. It doesn't fall from heaven. It doesn't come like manna. You have to go get it. And we have carefully constructed these provisions to allow us to do the kind of work that is necessary not to collect the bodies after a successful terrorist attack has occurred, but rather to prevent these terrorist attacks. One of the things people should keep in mind is that we have the intervention of federal judges in these three different areas of the law. It is not something where the executive branch is allowed to go unfettered into looking for this information. Rather, they must justify it to an independent federal court. And some say, oh my gosh, it's a secret court. It is a secret court because, in fact, there are certain secrets that must be maintained as we attempt as best we can to save this nation and our citizens from those who would attack us. One wonders at times whether we have the sense of urgency that is necessary to continue with the efforts to make us safe. The fact that we have thwarted successfully terrorist attacks is not a reason to dismantle the means which allowed us to do that. It is, in fact, a reason why we should continue this. Any honest examination of the history of this Judiciary Committee and the Crime Subcommittee will reveal that we have done the oversight necessary to ensure that we have the tools to fight the threat of terrorism and at the same time preserve the civil liberties of American citizens. To suggest otherwise is to ignore the record. To suggest it's unconstitutional is to somehow ignore the decisions made by every federal court that has looked at this. But you can continue to make these statements. You can continue to confuse the public. You can continue to raise alarm where alarm ought not to be raised. With all due respect, while everybody is entitled to their opinions, they are not entitled to their own facts. They must take the facts as they are. And the facts are this is constitutional, it is workable, it is necessary, we have to do it, and we have to do it now.
Time of the gentleman's expired. The gentleman from New York.
Mr. Speaker, I now yield 2 minutes to the gentleman from Maryland.
The gentleman from Maryland is recognized for 2 minutes.
Speaker, I rise in support of S 990. These three provisions of the Patriot Act provide important tools that help keep America safe. I am pleased that this bill includes sunsets. Our founding fathers created a system of government that included checks and balances between the three branches of government: legislative, executive, and judicial. Sunsets allow for the legislative branch to conduct meaningful oversight on an ongoing basis. I will support this extension because I believe that these provisions are consistent with the Constitution and provide the tools the government needs to keep us safe while protecting civil liberties. I yield back.
Gentleman yields back. The gentleman from Texas. Gentleman from Texas.
Mr. Speaker, we're prepared to close on this side, so I'll reserve the balance of my time.
Gentleman from New York.
Prepared to close now. Mr. Speaker,
Gentleman's recognized.
I yield myself such time as I may consume.
Gentleman's recognized.
Thank you, Mr. Speaker. Let me just say that we've heard all these arguments before, many times on this floor. It's hard for me to believe that a proper investigation and a proper procedures would not have been able to improve this bill or these provisions in any way, that all the hearings, all the suggestions that were made came to no changes at all. I'm not going to debate for the fifth time with Mr. Lundgren his statements. I do not believe they are accurate. He does not believe what I said are accurate. We're on similar ground there. Let me just say let me just say that I believe that these provisions should be amended. They should be changed. They are an overbroad violation of our rights, and leave it at that, and therefore I will oppose them. And before we conclude, I want to recognize Judiciary Committee Counsel Sam Sokol, who is leaving the committee tomorrow for what I know is a bright future. I know that I speak for every member of the committee in thanking Sam for his wise counsel, his prodigious capacity for work, and for his friendship. He has been a valued member of our team, and we will miss him greatly, and we wish you the best of luck, Sam. And with that, I urge the defeat of this bill, and I yield back the balance of my time.
Back his time. The gentleman from Texas.
Mr. Speaker, I'll yield the balance of my time to the gentleman from Pennsylvania, Mr. Marino. He's a member of the Judiciary Committee Crime Subcommittee. He's also both a former U.S. Attorney and District Attorney.
Gentleman from Pennsylvania is recognized for 5 minutes.
Thank you, Mr. Speaker. Mr. Speaker, it's incredulous of what I'm hearing here today from my friends on the other side of the aisle. I was a U.S. attorney and used the Patriot Act. I debated it, I lectured it, and I put a terrorist away by using the Patriot Act. I was also a district attorney, and I used it. It was easier.
Gentlemen, suspend. The House will be in order. The gentleman may continue.
Thank you. It was easier for me to get a warrant for documents as a district attorney than it was for me to get documents pursuant to the Patriot Act. I just could not sign a document and go get papers and have a wiretap. I had to go through a FISA judge. It had to go through my first assistant, myself, the Justice Department, a judge, and then back to the office for a signature. There is absolutely no circumstances where I could get information from a citizen who we believe to be a terrorist involved with terrorism by not getting a warrant. An example is the roving wiretap. The roving wiretap was designed for one specific reason. Wiretaps, when the wiretap law went into effect, were based on a phone being on a wall in a particular location. Over the years, because of cell phones, terrorists and criminals and drug dealers were buying and are still buying cell phones in 5 and 10 and 20 batches, using them for several minutes, dropping them, continuing the same crime, just switching to a new cell phone. The law allowed us not to have to go after a new warrant for each cell phone. That was logical because the phone was not attached to a wall in a particular location. They were roving. It has done its job not only in drug work, but terrorism work as well. The same thing for documents and information from business records and bank records. In some instances, as a district attorney, I didn't even need a warrant, and so I had to do a subpoena those documents. That is not possible under the federal system. We have to go through a FISA court to get those warrants. I've done that for 6 years as a U.S. attorney and for 12 years as a district attorney. What we are hearing from the other side is absolutely not true about warrantless searches. Earlier today, the Senate approved Senate 990 by a vote of 72 to 23 with overwhelming bipartisan support. It is time for the House to do the same thing. Time is of the essence. We have until midnight tonight to help keep America safe because the terrorists are out there continually working. They aren't taking breaks. These are common sense provisions that have worked effectively for 10 years to prevent terrorist attacks, protect the American people, and preserve civil liberties. They need to be extended for another 4 years. The terrorist threat we face as a nation has not expired. Neither should these important provisions that have helped keep us safe from terrorist attacks. I urge my colleagues to vote yes on this critical national security bill, and I yield back the balance of my time.
The gentleman yields back the balance of his time. There being no other request for time, all time for debate has expired pursuant to House Rule 281. The previous question is ordered. The question is on the motion by the gentleman from Texas, Mr. Smith. Those in favor will signify so by saying aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the motion is agreed to. Gentleman from New York.
I ask for a roll call vote.
Gentlemen, the nays and yeas are requested. Those favoring a vote by the yeas and nays will rise. Sufficient number having arisen, the nays and yeas are ordered. Members will record their votes by electronic device. This will be a 15-minute vote.
The House is voting now on extending the Patriot Act. 3 provisions on the measure dealing with wiretapping and surveillance expire at midnight. The Senate approved the measure this evening by a vote of 72 to 23, and the House needs to pass it before the legislation can go to the President. The Associated Press writes that with the President in Europe, if Congress approves the extension, the President will direct the use of the auto pen to sign it. That's an automatic signature machine used at the White House. So why is this happening so close to the midnight deadline? The Associated Press writes that the Senate struggled to find a way to stage the final vote in face of continued resistance from a single senator, Republican freshman Rand Paul of Kentucky. Senator Paul, a libertarian, objects to renewal of the expiring provisions on the grounds that they violate constitutional rights to privacy. So to get the vote in the Senate, Majority Leader Harry Reid allowed Senator Paul 2 votes this evening related to his amendments. One amendment would have excluded some gun records from Patriot Act investigations. Another dealt with suspicious activities reports. Both of these amendments were tabled or killed, allowing the Senate to then go on and approve the Patriot Act and send the bill here to the House for a vote. Right now, during this vote, we're going to hear Senators Paul, Durbin, and Chambliss on the Senate floor before that vote.
To come to the floor of the Senate to talk about the Patriot Act. I'm pleased that we have cracked open the door, that we will shed some light on the Patriot Act. I wish the door were wider open, the debate broader and more significant, but we will talk a little bit about the constitutionality today of the Patriot Act. I was a co-sponsor of Senator Lay's amendment, and I think it would have gone to many great steps forward to make sure that we have surveillance on what our government does. He would have authorized audits and the Inspector General to continue to watch over, to make sure that government is not invading the rights of private citizens, and I do support that wholeheartedly. Jefferson said that if we had a government of angels, we wouldn't have to care or be concerned about the power that we give to government. Unfortunately, sometimes we don't have angels in charge of our government. Sometimes we can even get a government in charge that would use the power of government in a malicious or malevolent way to look at the banking records of people they disagree with politically, to look at the religious practices of people they disagree with. So it's very important that we are always vigilant, that we are eternally vigilant of the powers of government, that they not grow to such an extent that government could be looking into our private affairs for nefarious reasons. We have proposed 2 amendments that we will have votes on today. One of them concerns the Second Amendment. I think it's very important that we protect the rights of gun owners in our country, not only for hunting but for self-protection, and that the records of those in our country who own guns should be secret. I don't think the government, well-intentioned or not well-intentioned, should be sifting through millions of records of gun owners. Why? There have been times, even in our history, when government has invaded your household to take things from you. In the 1930s, government came into your household and said, "Give us your gold." Gold was confiscated in this country in 1933. Could there conceivably be a time when government comes into your house and says, "We want your guns"? Well, people say that's absurd. That would never happen. I hope that day never comes. I'm not accusing anybody of being in favor of that, but I am worried about a government that is sifting through millions of records without asking, are you a suspect? Without asking, are you in league with foreign terrorists? Are you plotting violent overthrow of your government? By all means, if you are, let's look at your records. Let's put you in jail. Let's prosecute you. But let's not sift through hundreds of millions of gun records to find out whether or not you own a gun or not. Don't leave those data banks in the hands of government where someday those could be abused. What we're asking for are procedural protections. The Constitution gave us those protections. The Second Amendment gives you the right to keep and bear arms. The Fourth Amendment is equally important. It gives you the right to be free of unreasonable search. It gives you the right to say the government must have probable cause. There must be at least some suspicion that you are committing a crime before they come into your house or before they go into your records, wherever your records are. The Constitution doesn't say that you only have protection of records that are in your house. You should have protection of records that reside in other places. Just because your Visa record resides with a Visa company doesn't make it any less private. If you look at a person's Visa bill, you can find out all kinds of things about them. If you look at a person's Visa bill, you can find out what doctors they go to. Do they go to a psychiatrist? Do they have mental illness? What type of medications do they take? If you look at my Visa bill, you can tell what type of books I read, what type of magazines I read. One of the provisions of the Patriot Act is called the library provision. They can look at the books you check out in the library. Well, people say, well, still a judge has to sign these warrants. But we changed the standard. The standard of the Fourth Amendment was probable cause. They had to argue or at least convince a judge that you were a suspect, that you were doing something wrong. Now the cause or the standard has been changed to relevance. So it could be that you went to a party with someone who was from Palestine who gives money to some group in Palestine that may well be a terrorist group or not. But the thing is, because I went to a party with them, because I know that person, am I now somehow connected enough to be relevant? And they would say, well, your government would never do that. They would never go and investigate people. The problem is, this is all secret. So I don't know if I've been investigated. My Visa bills sometimes have been $5,000. Sometimes we pay for them over the phone, which is a wire transfer. Have I been investigated by my government? I don't know. It's secret. What I want are protections. I want to capture terrorists. Sure, if terrorists are moving machine guns and weapons in our country, international terrorists, by all means, let's go after them. But you know, the worst people, the people we want to lock up forever, the people all of us universally agree, people who commit murder, people who commit rape, we want to lock them up and throw away the book, and I'm all with you. But we still have the protections of the Fourth Amendment. If someone is running around in the streets of Washington tonight at 4 in the morning and we think they may have murdered someone, we will call a judge and we will get a warrant. Just because we believe in procedural protections, just because we believe in the Constitution, doesn't mean that we don't want to capture terrorists, but we just want to have some rules. I'll give you an analogy. Right now, you've been to the airport. Most of America has been to the airport at some point in time in the last year or two. Millions of people fly every day. But we're taking this shotgun approach. We think everyone's a terrorist. So everyone's being patted down. Everyone's being strip searched. We are putting our hands inside the pants of 6-year-old children. I mean, have we not gone so far? Are we so afraid that we're willing to give up all of our liberty in exchange for security? Franklin said, if you give up your liberty, you'll have neither. If you give up your liberty in exchange for security, you may well wind up with neither. Because we take this shotgun approach, we take this approach that everybody's a potential terrorist, I think we actually are doing less of a good job in capturing terrorists. Because if we spend our time going after those who are committing terrorism, maybe we'd spend less time on those who are living in this country, children and otherwise, frequent business travelers who are not a threat to our country. Instead of wasting time on these people, we could spend more time on those who would attack us. I'll give you an example. The underwear bomber. For goodness sake, his dad reported him. His dad called the U.S. Embassy and said, my son is a potential threat to your country. We did nothing. He was on a watch list. We still let him get on a plane. He'd been to Nigeria. He'd been to Yemen twice. For goodness sakes, why don't we take half of the people in the TSA who are patting down our children and let's have them look at the international flight manifest of those traveling from certain countries who could be attacking us. For goodness sakes, why don't we target who we're looking at? My other amendment concerns banking records. 8 million banking records have been looked at in our country. Not by the government. They've empowered your bank to spy on you. Every time you go into your bank is asked to spy on you. If you make a transaction more than $5,000, the bank is encouraged to report you. If the bank doesn't report you, they get a large fine in the tune of $100,000 or more. They could get 5 years in prison. They are over-encouraged. The incentive is for the bank to report everyone. So once upon a time, these suspicious activity reports were maybe 10,000 in a year. There are now over 1 million of these suspicious activity reports. Do I want to capture terrorists? Yes. Do I want to capture terrorists who are transferring large amounts of money? Yes. But you know what? When we're wasting time on 8 million transactions, the vast majority of these transactions being law-abiding U.S. citizens, we're not targeting the people who would attack us. Let's do police work. If there are terrorist groups in the Middle East and we know who they are, let's investigate them. If they have money in the U.S. or they're transferring it between banks, by all means, let's investigate them. But let's have some constitutional protections. Let's have some protections that say you must ask a judge for a warrant. Some have said, how would we get these people? How would we capture those who are transferring weapons? We would investigate. We have all kinds of tools, and we've been using these tools. Others have said, well, we've captured these people through the Patriot Act, and we never could have gotten them. The problem with that argument is it's unprovable. You can tell me that you've captured people through the Patriot Act, and I can believe you've captured them and you've prosecuted them, but you can't prove to me that you wouldn't have captured them had you not asked for a judge. We have a special court. It's called the FISA court. The FISA court's been around since the late 1970s. Not one warrant was ever turned down before the Patriot Act. But they say we need more power. We need more power given to these agencies, and we don't need any constitutional restraint anymore. But my question is, the Fourth Amendment said you had to have a probable cause, you had to name the person and the place. Well, how do we change and get rid of probable cause and change it to a standard of relevance? How do we do that and amend the Constitution without actually amending the Constitution? These are important constitutional questions. But when the Patriot Act came up, we were so frightened by 9/11 that it just flew through here. There weren't enough copies to be read. There was one copy at the time. No senator read the Patriot Act. It didn't go through the standard procedure. And look at what's happening now. 10 years later, you'd think the fear and hysteria would have gotten to such a level that we could go through the committee process. Senator Leahy's bill went to committee. It was deliberated upon. It was discussed. It was debated. It was passed out with bipartisan support. It came to the floor with bipartisan support, but you know why it's not getting a vote now? Because they backed us up against a deadline. There have people who have implied in print that if I hold the Patriot Act up and they attack us tonight, that I'm responsible for the attack. There have been people who have implied that if some terrorist gets a gun, that I'm somehow responsible. It's sort of the analogy of saying that because I believe that you should get a warrant before you go into a potential or alleged murderer's house, that somehow I'm in favor of murder. I'm in favor of having constitutional protections. These arose out of hundreds of years of common law. They were codified in our Constitution because we were worried. We were incredibly concerned about what the king had done. We were concerned about what a far distant parliament was doing to us without our approval. We were concerned about what James Otis called writs of assistance. Writs of assistance were pieces of paper that were warrants that were written by soldiers. They were telling us we had to house the British soldiers in our house, and they were giving general warrants, which meant we're just going to search you willy-nilly. We're not going to name the person or place. We're not going to name the crime you're accused of. If a government were comprised of angels, we wouldn't need the Fourth Amendment. What I argue for here now is protections that protect us all should we get a despot, should we someday elect somebody who doesn't have respect for rights. We should obey rules and laws. Is this an isolated episode that we're here talking about the Patriot Act and that there's an insufficient time? It's a deadline, hurry, hurry, we must act. It's not an isolated time. We've had no sufficient debate on the war with Libya. We are now encountered in a war in Libya. So we now have a war in which there's been no congressional debate and no congressional vote. But you know what they argue? They say it's just a little war. But you know what? It's a big principle. It's the principle that we as a country elect people. It's a principle that we are restrained by the Constitution, that you are protected by the Constitution. And if I ask the young men and women here today to go to war and say we are going to go to war, that there darn well should be a debate in this body. We are abdicating those responsibilities. We are not debating the Patriot Act sufficiently. We're not having an open amendment process. Yes, am I pleased? It took me 3 days of sitting down here filibustering, but I'm going to get 2 amendment votes. I am very happy, and I am pleased that we came together to do that. I wish we would do more. I wish Senator Leahy's bill were being voted here on the floor. I wish there were a week's worth of debate. The thing is we come here to Washington expecting these grand debates. I've been here 4 months. But I expected that the important questions of the day would be debated back and forth. Instead, what happens so often is the votes are counted and recounted and laboriously counted. And when they know they can beat me or when they know they can beat somebody else, then they allow the vote to come to the floor. But some, like Senator Leahy's bill, I'm suspicious that it's not going to be voted on because we may not be able to beat it, or they may not be able to beat it. I support it. So the question is, should we have some more debate in our country? We have important things pressing on us. I've been here for 4 months, and I'm concerned about the future of our country because of the debt burden, because of this enormous debt we're accumulating. But are we debating it fully? Are we talking about ways we could come together, how Republicans and Democrats, right and left, could come together to figure out a crisis, this crisis of debt? No, I think we're so afraid of debate. But particularly with the Patriot Act, the thing is with the Patriot Act is that it's so emotional, because anyone who stands up like myself and says we need to have protections for our people, that we shouldn't sift through every gun owner in America through their records, looking and just trolling through records. Interestingly, we have looked at 28 million electronic records when the Inspector General looked at this. 28 million electronic records. We've looked at 1,600,000 texts. Now, if you said to me, well, they asked a judge and they thought these were terrorists, I don't have a problem. Judge gives them a warrant and they look at these text messages or electronic records. But do you want them trolling through your Facebook? Do you want them trolling through your emails? Do you want a government that is unrestrained by law? This ultimately boils down to whether we believe in the rule of law. So often we give lip service to it on our side and the other side, and everybody says, we believe in the Constitution and the rule of law. When you need to protect the rule of law is when it's most unpopular. When everybody tells you that you're unpatriotic or you're for terrorism because you believe in the Constitution, that's when it's most precious. That's when it is that you need to stand up and say, no, we can fight. We can preserve our freedoms. We are who we are because of our freedoms and our individual liberty. If we give that up, we're no different than those who we oppose. Those who wish to destroy our country want to see us dissolve from within. We dissolve from within when we give up our liberties. We need to stand up and be proud of the fact that in our country, it's none of your darn business what we're reading. It's none of your business where we go to the doctor or the movie or what our magazines are. It's nobody's business here in Washington what we're doing. If they think it's the business of law enforcement, get a warrant. Prove to somebody, at least have one step that says that person is doing something suspicious. The thing is these suspicious activity reports, 8 million of them have been filed in the last 8 years. The government doesn't have to ask for this. It's sort of like they have deputized the banks. The banks have now become...
You can see the rest of this Senate debate on the Patriot Act at cspan.org. Here in the House, members wrapping up this vote on extending the law. This is the last legislative business expected for the week. Also earlier today, on a 322 to 96 vote, the House approved the Defense Programs Bill for 2012 that would provide a 1.6% increase in military pay, fund an array of aircraft, ships, and submarines, and also increase health care fees slightly for working-age military retirees. That measure must still go to the Senate for consideration, and the White House has threatened a veto of several provisions of that bill.
And this